Hello, everyone, and welcome to the final session of ELI Summer 2021 Summer School on Environmental Justice. My name is Nina Pusick, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. I would like to take a moment today to thank our outstanding panelists for joining us to lend their expertise to our final session. This session explores foundations, case studies, current opportunities for federal environmental and climate justice legislation, obstacles facing environmental justice, and what facilitating environmental justice can look like within the legal practice. While I will introduce our moderator briefly, full speaker bios are posted on our website, eli.org, and I would encourage you to check out their expertise in more detail there. Following each panelist presentation, we will then move on to an open discussion and question and answer session. You can submit your questions through GoTo's question box, and please do not wait until the end. Send your questions as soon as you think of them. It is my enormous pleasure to introduce and welcome back our expert moderator for the session, Christine Perry, our in-house staff attorney at ELI, who is committed to advancing human rights in the environmental context with a particular focus on gender and disability. She works primarily on international issues with a focus on Latin America. She has experience in judicial training on deforestation issues in Colombia, environmental crimes in Peru, migration with dignity, as well as enforcement issues more broadly. Prior to joining ELI, she worked for Amnesty International Secretariat Law Policy Program. Her work on international human rights focused on the rights of persons with disabilities, gender, policy development, and strategic litigation. She also has experience in refugee and migrants' rights. Thank you so much for joining us as our moderator today, Christine. And with that, I'll turn things over to you. The floor is all yours. Thank you.
Thank you, Nina. As Nina said, I am a staff attorney here at ELI with a keen interest in both environmental and human rights issues. And without further ado, I would like to introduce you to our esteemed panel that we have today. First, we have Gerald Torres, and he is a professor of environmental justice at the Yale School of Environment and a professor at Yale Law School. He is a former president of the Association of American Law Schools and has taught at Stanford Law School and at Harvard Law School, where he served as the Oneida Nation Visiting Professor of Law. Professor Torres served as counsel to the Attorney General on environmental matters and Indian affairs at the U.S. Department of Justice. Professor Torres has served on the board of the Environmental Law Institute, the EPA's National Environmental Justice Advisory Council, and the National Petroleum Council. He is on the board of Earth Day Network and founding chairman of the Advancement Project, the leading civil rights advocacy organization in the country. He is a trustee on the Natural Resources Defense Council. Professor Torres has just been appointed to the Advisory Council of the Connecticut Sea Grant. He has served as a consultant to the United Nations on environmental matters and is a life member of the American Law Institute and the Council on Foreign Relations. Also joining us is Dr. Beth Rose Middleton Manning. She is a professor of Native American Studies at UC Davis with a focus on Native environmental policy, Indigenous adaptations to climate change, rural environment justice, and Native activism for site protection using conservation tools. She is the author of 2 books, Trust in the Land, New Directions in Tribal Conservation, which focuses on Native applications of conservation easements and upstream, Trust Lands and Power on the Feather River, on the history of Indian land rights and hydroelectric development in northeastern California. She mentors graduate students in Native Studies, Ecology, Geography, and Public Health, and is passionate about supporting Indigenous land access, restoration, protection, and stewardship, and increasing diverse perspectives in environmental policy and planning. Next, we are joined by Rue Musa, and she is an environmental litigator and counselor with Beveridge & Diamond in Washington, D.C. Her practice areas include climate change, sustainability, and environmental justice. Prior to joining the firm, Rue worked at a Fortune 50 company, although I believe, should that say 500? Company where she helped formulate a climate change strategy, build coalitions, and respond to federal environmental regulations. We are also joined by Kiana Courtney. She is a staff attorney in Chicago, Illinois at the Environmental Law and Policy Center, working on clean water and clean air matters, including coal ash pollution, air quality monitoring with community science, the perpetuation and exacerbation of climate change, and challenging and reviewing permit compliance. She strives to apply an environmental justice lens to all of her work. Kiana received her JD from the University of Miami School of Law, and she attended Wake Forest University, where she received her undergraduate degree in communication with a concentration in rhetorical studies and a double major in environmental studies and sociology. Prior to law school, she was a middle school science teacher in Atlanta Public Schools. And finally, we have Daria Neal, and she is a deputy chief in the U.S. Department of Justice Civil Rights Division, Federal Coordination and Compliance Section. Ms. Neal oversees a team of attorneys who work with the federal agencies to ensure consistent and effective enforcement of civil rights statutes and executive orders that prohibit discrimination in federally conducted and assisted programs and activities, including Title VI of the Civil Rights Act of 1964. Ms. Neal has represented the Civil Rights Division on the White House Environmental Justice Interagency Council and leads its Title VI committee to improve interagency coordination of civil rights enforcement in matters related to the disparate environmental and health burdens of pollution. Prior to joining the Department of Justice, Ms. Neal was a senior counsel for the Environmental Justice Project at the Lawyers Committee for Civil Rights under Law. Ms. Neal is a proud graduate of Hampton University and received her law degree from the University of California, Los Angeles School of Law. We are so excited to have all of these panelists with us today, and without further ado, I'd like to turn it over to them.
Well, thank you. I think I'm supposed to start. I want to thank ELI for giving me the opportunity to be here today. I'm glad to see a large number of people tuning in, and I guess it's called tuning in, I'm not even sure. And I'm honored to be a panelist with this esteemed panel. I mean, the work that my co-panelists have done is transformative, and I think we'll probably see some of that today. What I'm going to do is try to lay out the framework. If I can control the slides, we'll see. Lay out the framework for environmental justice and try to give a little bit of framing history for this, and end up with a kind of a discussion of what this means for practice. And I'd be happy to answer questions you have. So I'm essentially laying out the introduction. So I'm going to start with Executive Order 12898, which was adopted in the Clinton administration, and I was grateful to have played a role in the drafting of that. And I'm also grateful to have seen the criticisms that have emerged in response to the limitations, or in fact the limitations in what could be done through executive action alone, where the idea of environmental justice hadn't yet completely percolated through the policy corridors. The one thing I want to say before I talk about the executive order is the role that environmental justice activists played. That in fact it would not have gotten on the agenda either in the Clinton administration or probably subsequently in the Biden administration, if in fact there hadn't been a concerted effort of activists who have in many ways framed the issue, but have also not just framed the issue, but defined the emerging characteristics that have to be taken into account when environmental justice is viewed as a policy issue. I will also say that activists, in my view, have a much broader view of what constitutes environmental justice claims that has yet to be completely assimilated into the policies that are adopted by government. So in any event, environmental justice, the Executive Order 12898 was designed, one, to define environmental justice communities, and then to make it a task of every administrative agency to build into their programs a consideration of environmental justice. So, having said that, the basic charge that you see here, right, was to identify and address as appropriate the disproportionately high and adverse environmental and human health effects of its programs on minority populations and low-income populations. So that was the basic charge that the executive order gave to the various agencies. How those agencies were supposed to operationalize that charge became the task of the remaining period of the Clinton administration. One of the things that I think it's important, certainly in the current moment we're in, to stress is that leadership from the top matters, and that unless you have leadership from the top, the agencies, and I mean real leadership, I mean committed leadership, that where there's consequences for not following through. Agencies, you know, there are many ways to slow things down. So the in the Obama administration, the EJ plan was promulgated, and what it did was to look at using both civil rights and environmental regulation to implement the executive order. Now, you all, or most of you already know that trying to use Title VI, which was the initial NEJAC, focused on as a way to regulate federal funding and to incorporate environmental justice planning in agencies, came a cropper, right? When the court held that there was no private right of action. So what's going to be, and I think one of the things that I hope that we can look forward to is for aggressive affirmative litigation brought by the government under Title VI, since there's a tool there and it ought to be used. I also need to be clear that the existing environmental statutes weren't built with environmental justice at their core. Right. So, in fact, a lot of what has to happen is a kind of a retrofitting of environmental justice ideas into the regulatory structure, which brings me to some of the limitations. So the executive orders had to implement to the greatest extent practicable and permitted by law, right, the charge of the executive order. Well, that, of course, is both a command, but also a limitation. So the current effort is to make environmental justice, as I say here, more intelligible. And so the proposed revision to 12898 is what you see on the screen. The initial executive order, right, had a couple of obligations, right? It's the obligation to fair treatment and an obligation to provide a meaningful involvement in policymaking. So the one thing is it incorporates a definition of justice, right? But also recognition that process failure is one of the impediments to implementing what the environmental justice advocates said was needed. Now, the idea of what justice means, right, remains, I think, at the heart of the evolving implementation and statement of what the environmental justice practice ought to look at. So the key thing then is defining justice. If it's just distributive justice, that is to make sure the environmental burdens are shared more fairly, right? The environmental justice community said, well, you know, that's not what we want, right? We don't want everyone to be made to suffer. What we want is an investigation and critique of the system of environmental regulation so that we reduce the pollution and the environmental burden on all communities, perhaps beginning with the folks in those communities that are already bearing a disproportionately large share of the environmental burden. So what's emerged in the academy are these three different definitions of justice. Compensatory justice, which suggests that in fact there's already a debt to be paid. And so the key question there is who pays and what are they paying for? The procedural justice means that you really have to take seriously the exclusion of specific voices from the discussion. The recognition justice is important because it says you have to take communities in the cultural and socioeconomic setting that you find them. Now, the native critique of recognition justice is actually profound, and I'm really happy that Dr. Middleton Manning is with us, because the native critique in some ways remains, in my view, some of the sharpest critique and the most important. Okay, so one of the questions was the difference between equity and equality. I've already said that equality in terms of just the fair share of the fair distribution of the burden isn't what environmental justice advocates wanted. What they wanted was both fair participation and overall commitment to reducing the environmental burden that we all share. So in some ways, it's taking a leadership role in defining what environmental protection ought to mean, right? And that, in the context of climate change, continues to be important. Oops, I think I skipped ahead. So what do these concepts mean? Well, for purposes of practice. Well, the first thing is it gives you a way to interrogate the existing regulatory structure. So what you can do is you can go back to the Plan EJ 2014, which walks through the statutes. You can look at the report of the WEJAC, which looks at reforming the executive order, and you can ask, taking the critique that comes from the academy and the movement, and ask, do these go far enough? Are these the kinds of changes that are necessary, that need to get made in order to push forward the environmental justice advocates had way back at the beginning? Now, you know, without wanting to date myself too much, right? The first environmental justice movement meeting I attended was in 1978. So while it seems like it's getting a lot of traction, there is a lot of work in communities over a generation to get it the traction that it has gotten. So I hope that's it's a rough framing. Why don't I leave it there? and turn it over to the next presenter. Thank you. I'd be happy to answer any question you have and be more specific if necessary. I look forward to your questions later. Thank you.
Thank you so much. That was just an incredible framing, very powerful, and I hope I can kind of extend some of the areas of inquiry and focus that Dr. Torres shared with us. So thank you again for having me. I'll be speaking today about Indigenous environmental justice, context, and cases. Again, I'm really grateful to be here with this esteemed panel. Next slide, please. So I always begin here with the context of the United States or North America being indigenous homelands, and so that being foundational to any conversation of environmental justice and of the foundational injustice of seizure of indigenous homelands and waters. Next slide, please. So next, you can go ahead and bring up these bullet points. Thank you. So environmental justice at its heart, and Indigenous environmental justice more specifically, begins with facing colonial legacies, all of the ways in which Indigenous land tenure was disrupted, treaties that were never upheld, the concept of encroachment by which settlers could move onto Indigenous lands and then claim it as theirs. That comes up with the Treaty of Ruby Valley in Nevada. The allotment or division of tribal lands against the will of tribal members, the violent seizure of lands, which we have a history of here in California, government-led removal and forced land redistribution, but more than just tenure, its relationship to land, responsibility to care for land and water, a context of stewardship that is part of everyday life and deeply intertwined with identity, family, and community. And the continued denial of Indigenous, oops, I saw some change there, but I'll keep going. The continued denial of Indigenous rights and responsibilities to tend homelands has real consequences, which I believe we're seeing now with catastrophic wildfire, for example, and the criminalization of Indigenous people who are punished for carrying out their responsibilities to care for their homelands that are now claimed as under another jurisdiction. And within that as well, the lack of access are health issues, and I'll touch on that. And I really appreciated what Dr. Torres brought out about compensation and sort of these broader, deeper aspects of environmental justice. Next slide, please. So I'm speaking mostly from California. I'm in Patwin homelands in Central California, where UC Davis is. On the left is a map of Indigenous homelands across California. On the right is a map of the lands that are recognized as under tribal jurisdiction. Much smaller areas due to a history of non-ratification of treaties and the seizure of tribal lands. So this is what I call the California Indigenous environmental justice context. IEJ partially building on the work of Kari Norgard and of Dina Julia Whitaker, Kyle White, and many others. Next slide, please. So my work is really focused on education and empowerment through research and advocacy. And some of the projects I'm grateful to collaborate on focus on the history of tribal lands and waters, how they came, how they were taken from tribal ownership, and linking that to the present, to contemporary exclusions of Indigenous peoples as well as other peoples' exclusions in environmental policy and practice. And I'll talk more about that in a moment. And then looking at contaminants, how they came into the water. The picture on the top is at the confluence of the Klamath and Trinity Rivers in northwestern California on the Yurok Reservation. We've been engaged in a project with them for several years, looking at contaminants in the Klamath that may come from illegal marijuana grows, old timber infrastructure left on the land, and perhaps agriculture further upstream. So looking at these contaminants, their sources, and people's exposure, an understudied area really led mostly by tribal environmental departments. So thinking about how universities and other parties can partner with tribes and with communities to address these contamination issues. And then a broader source of advocacy to address land return, land and water cleanup, and co-management. The two maps on the bottom deal with tracing the historical seizure of tribal lands and then advocating for access, stewardship, and co-management. Next slide, please. This is a book project I worked on in partnership with the Maidu Summit Consortium and the Maidu Culture and Development Group, as well as others. We were looking at the historic Indian allotments. These are allotments on the public domain, so smaller trust parcels set aside for individual Indigenous people, Maidu in this case mostly, but also Pit River up to the north and Washoe to the east, and then it been passed down in families if they were able to be retained in trust status. So the focus of this book was looking at the development of hydroelectric power that went on to feed the rest of the state with no compensation and no consultation with Indigenous people. So the flooding of lands for which there was no restitution provided, advocating to address that now in sort of this environmental justice context that takes into account history and its connection to the present and what can we do about it at this moment. Next slide, please. I'm going to just talk a little bit about this project. This is some of the evidence I found in the archives showing Indian allotment lands, in this case for a Maidu gentleman, that you can see the coordinates crossed off and patented to the power company. Next slide, please. And this is not an uncommon story. This is the flooding of tribal lands without notice for many people. Next slide, please. And the development of a private power system that benefited the San Francisco Bay Area. Next slide, please. Again, later touted as a source of water for the development of the rest of the state with the development of the California State Water Project for which this is at the headwaters. Next slide, please. And the salmon can no longer come up the North Fork Feather River. Again, not a unique story, although I'm focusing on the feather. This is very common, the placement of dams without any consent and these massive disruptions of tribal lifeways that last decades. This large dam was put in the late 50s and the smaller dams as early as around the turn of the century, but all of them create a stairway of power that blocks the passage of salmon. So again, from an EJ perspective, no benefits locally, but all of the harms. Next step, please. Next slide. I'm kind of fast forwarding through a long struggle that took almost 20 years working with Pacific Gas and Electric, which is one of our major utilities, to navigate their process by which they were required to divest some of their lands that were non-essential for hydropower production in a settlement with the California Public Utilities Commission following bankruptcy around the year 2000. Over the course of many years, the Maidu Summit, Maidu Culture and Development Group, and others advocated for the return of some of these lands to Maidu people. There was a strong, I think, impulse among non-Indigenous people to view the past as a foregone conclusion and just figure out how to get these lands into some sort of conservation ownership, whereas we were really able to elevate the fact that these were Indigenous lands that had been seized directly for this power development that had never been addressed. And so part of the outcome was the return of at least some lands. This is 2,500 acres in Tasmamkoyam or Humbug Valley, and this is the celebration or ribbon cutting with some youth of a couple years ago. Next slide, please. Next slide. Yes, thank you. This is also in Tasmamkoyam, and this is a project that involves some of our students at UC Davis, Native students working to grow out seeds provided by tribal members from different tribes. This, in this case, was the Maidu Summit, was elderberry and other plants that are culturally important. She learned how to grow them out in the greenhouse on campus, and then we were involved in a collaborative restoration project. So again, another aspect of EJ that's really hands in the soil, land restoration and stewardship in community-led work. Next slide, please. I wanted to briefly touch on fire. This is kind of a painful issue to talk about at the moment, given that wildfires are raging in Northern California. We have family members that are displaced at this moment. But I really, again, want to link past to present and think about the exclusion of traditional management, which involved regular burning and tending and cultivation and stewardship within forested and other landscapes. Now, without that stewardship, the active criminalization of that stewardship, the forests are often left untended, overgrown, and ripe for the impacts of climate change, increasing drought, for example. Next slide, please. And so this has been covered for many years in the national climate assessments, et cetera. And you can bring up all these bullet points if you don't mind. Just want to draw attention to the importance of cultural burning. There's so much literature coming out about cultural burning right now. And in the last several years, there's even newer articles that could be on this list. But underscoring that leading academic and practitioner science shows the effectiveness of burning for multiple co-benefits, including increasing habitat, raising the water table, improving overall ecosystem health as well as community health, and buffering landscapes against the risk of catastrophic fire. Next slide, please. So we have a course called Keepers of the Flame, which I'm very honored to be able to work with North Fork Mono Chairman Ron Good, Nisanan and Wintune cultural educator Diana Almendarez, and many others to learn about the application of cultural burning, to participate in burning and restoration projects, to study the policy context in which cultural burning is discouraged, and figure out pathways around that. Next slide, please. Again, developing an opening for restitution and for addressing environmental justice through hands-on work. This is a picture of some of our students being instructed by Chairman Good on doing some landscape restoration using burning. Next slide, please. You can keep going through these slides. These are some photos of our work together with sourberry and elderberry, learning about the application of fire and mixing in ash into the soil for healthier soils. And then the outcome, weavers being able to gather, again, in that area, healthy plants. You can bring up these bullet points, please. So a few perspectives from participation in state aspects of state aspects of Indigenous environmental justice. I was involved in the equity panel for the 30 by 30 initiative. That's California's initiative to conserve 30% of its natural and working lands by 2030. And again, I want to underscore that we can't just repeat the same perspective on conservation that has led to enclosure, lack of access, and creating the conditions that support catastrophic fire. So how can we forward Indigenous land stewardship, and how can we link that work in practice to the apologies that have been issued, in our case, Executive Order N1519? How can we link that to land policy? And I will talk briefly now about the beneficial uses of water and how to expand the application of cultural and subsistence beneficial uses. Next slide, please. And I think this relates well to what Dr. Torres was bringing up as well, in that there is a whole area of lack of attention to Indigenous people's relationship to water, exposure to contaminants in water, as well as non-Indigenous people who depend on the local environment for subsistence. So the State Water Board defines beneficial use categories, then regional water boards designate specific water bodies with known beneficial uses, and water quality objectives follow to protect those beneficial uses and place limits on pollutants to protect those uses. Next slide, please. So that's the overview of the implementation. These are some of the examples of the beneficial uses that are recognized, that have been recognized, as you can see them listed here. Next slide, please. In 2013, and this had been building on years of advocacy and work, tribes sent a letter to the State Water Resources Control Board stating that existing beneficial uses, some of which you saw on the previous slide, did not protect their cultural uses or tribal subsistence fishing practices. There was a lot of review and consultation and development of language. In 2016, the Water Board adopted a resolution directing staff to develop new beneficial use categories pertaining to tribal traditional and cultural uses, tribal subsistence fishing, and subsistence fishing by other cultures. And there's a little language about the importance of this. Next slide, please. And I want to recognize the work of many leaders who moved this forward. Fraser Schilling, who's a researcher on our campus, developed a tribal fish use study in consultation with many partners. The idea was to be able to quantify fish consumption. This is challenging throughout the state, but in order to show this is how much people are eating out of these different water bodies, water quality standards need to protect those uses that have heretofore been completely unrecognized. Next slide, please. So this is the language that was developed. There are now 3 new beneficial use categories, but they're not applied throughout the state. They have to be applied in specific regions on specific water bodies through a whole process which kind of mimics the study that Fraser did previously. So these are the 2 categories that I'm focusing on. I'm not going to read them right now, but tribal traditional and cultural use. Next slide, please. And tribal subsistence fishing use. Next slide, please. Again, recognizing these uses that had been ignored. Here's a map of the water boards. Again, the process is to conduct studies in each region to make the case for the application of the beneficial uses on specific water base. Has to be data-based. And I'm working now with many others in Region 5 around exploring this process and applying the tribal beneficial uses to water bodies in this jurisdiction. Next slide. And beneficial uses then emerge as a key tool, a way to ensure that to insert tribal values into the water quality regulatory process, even though it's awkward with this challenge of trying to quantify what is a deeper relationship to the water and to the different species in the water. So another aspect is that tribes are applying these beneficial uses to argue for expanded protection of water quality. And there's a quote here that's quite powerful, I think, taken from Dr. Norguide's book, Salmon and Acorns Feed Our People. Next slide, please. So some of the remaining concerns, though, around the beneficial uses are who is gathering the data and who is gathering it appropriately to support the protection of tribal values and interests, how long it takes, again, all these studies, applying it to each waterway. In all that time, people are still exposed, still consuming everything that comes out of the river, still going in the river, and the water quality objectives don't reflect that level of exposure. And then enforcement is the third issue. Once the water quality objective is established, knowing that there's that intensive use, is it enforced? Next slide, please. So again, just wrapping up here a few of the Indigenous environmental justice interventions. Education, many of us work in education, but hands-on learning guided by respect and reciprocity, and that deep acknowledgement of the racism and settler colonial violence that's embedded in many accepted institutions, facing that and figuring out what to do about it to not repeat the cycles of the past. Then policy questions, what are the barriers to the development of Indigenous-led projects? Also to the development of rural underrepresented community-led projects, to the application of traditional methods for land restoration. What are the opportunities? Are there policy levers, like potentially the beneficial uses that we can push? What about incentives for land return? What about barriers there and policy levers as well? Next slide, please. And that's it. Thank you so much.
Hi everyone, I'm up next and my name is Rue Musa, and today I'm going to be just providing you a brief overview of what's going on at the state level regarding environmental justice. And then I'm going to provide you with a little bit of insight of what it's like to be an attorney in private practice dealing with EJ issues. And then finally, for those of you in the crowd who are students, I'll provide you with a couple tips that are hopefully helpful if you are considering a career in environmental justice, which you absolutely should be considering. So there's a lot going on currently regarding environmental justice. And as Professor Torres explained, EJ has been around, I call it EJ for short, it has been around since the 1960s. That's when it has its roots. But really, it's having a moment right now due to a confluence of a variety of factors, including the recent social justice movement, the inequities that have been highlighted by the COVID-19 pandemic, the growing awareness about climate justice, which means who's going to be hit the hardest by climate change, and also the recent election. Biden really campaigned on a platform involving environmental justice, and at the federal level now he's had to make good on some of those promises. And so all these factors together have really brought environmental justice to the forefront of a lot of people's minds and legislatures' minds. And we're seeing that same trend at the state level. And so now a majority of states actually have laws and policies that address environmental justice, with fewer than 5 states having, less than nothing in place, essentially. But the extent to which states are tackling EJ really does vary. So on the screen, I've kind of highlighted a few states with some sophisticated or mature environmental justice regimes. California, no surprise there, has been a bit of an EJ pioneer. They have a pretty robust environmental justice subdivision in the state attorney general's office, which is in charge of some environmental justice enforcement. They also have the California EnviroScreen, and that's just an EJ mapping tool that is well utilized. And then turning to Massachusetts and Connecticut, both of those states, they have certain EJ policies that really provide for meaningful engagement. And Virginia and Minnesota are 2 other states that are often fairly active in the environmental justice space. So it's really important that states are getting involved and they're leaning in, because states are a little bit closer to the ground than the federal government is. And EJ issues are very local in nature, so states are well positioned to deal with environmental justice concerns. So there's a lot of players at the state level that are driving the change in the environmental justice arena, one of which are state agencies, so like state versions of the EPA. A lot of states are setting up advisory groups. So for an example, North Carolina, they have an environmental justice task force, and they recently published a report kind of outlining policy recommendations to address disparities in communities of color, in particular in relation to COVID-19. And so if you're looking to see what a state is doing, looking at the agency level, that's a really great place to start, especially with those mapping tools as well. The legislature, so people who are actually passing the laws related to environmental justice, there's a lot of laws that are being passed, a lot of laws that are being introduced, and quite frankly, there's a lot of laws that are failing as well, but it's important to look to the state legislature to see what's going on. Courts also play a very important role. So in particular, when a state attorney general is bringing a lawsuit and enforcement action regarding environmental justice, it's important to look to see what courts are doing. Are they really in favor of the community? Are they really in favor of the emitting facility? What kind of precedent is being set at the state level? And then finally, NGOs, they're doing a lot of work. And I know we have a lot of people from NGOs on this call as well. So we heavily applaud you. They're close to the ground, doing a lot of work. Universities are doing really great work, in particular with helping set up these EJ screening and mapping tools. So for example, the University of Maryland, they have their EJ score tool, which has been really helpful out in Maryland. So to kind of put that into context, I'm just going to talk about one state in particular just to kind of illustrate how environmental justice is being addressed in that state. And so I'm going to talk about New Jersey, because last September they the legislature passed and the governor signed into law a piece of landmark environmental justice legislation, which essentially empowers the state environmental department to restrict or deny permits for certain facilities based on environmental justice impacts. So essentially, polluting facilities, they need to do an environmental justice impact statement, and then the agency has the ability to deny a permit if the cumulative environmental or public health stressors of the facility are too great. And so this is a piece of landmark legislation, and other states have even replicated the model. So for example, Georgia's HB 431, the HEAL Act, was introduced, it hasn't been passed yet, but really heavily turns to and relies on some of the language that was used in New Jersey. And then on the enforcement side for New Jersey, the state attorney general last year filed about 12 environmental justice related lawsuits targeting polluters in low income and minority communities. So it's that combination of new legislation that actually empowers the state agency to go forth, and then the state attorney general taking an aggressive position and actually targeting and bringing lawsuits against these polluters that can really create some meaningful change at the state level. And as you can see on the screen, I've listed a few other states, but really there's so much happening. It's hard to capture everything. Nearly 20 states have actually introduced environmental justice related legislation this last year. So I'll just quickly talk about some recent developments over the past month. Maybe you haven't heard of these. One of which was Washington. They passed a piece of legislation essentially amending an existing environmental justice program. Colorado, they passed HB 1266 just this last month. And essentially it's creating an environmental justice task force within their state Department of Public Health and the Environment. And that department is tasked with producing practical ways to address environmental justice inequities. It also defines what it means to be a disproportionately impacted community. And it also requires the state's air division to reach out to those communities. Another example is Rhode Island. They recently passed some environmental justice legislation as a part of a broader climate change law. They have this 2050 net zero goal regarding emissions. And as a part of that, they have specifically asked that they address environmental injustices, public health inequities, and just ensuring that there's going to be a clean, there's going to be an equitable transition from fossil fuels in the state to clean energy jobs. Rhode Island has a few other pieces of legislation that are still pending, and they have a lot of legislation that's also died, but it's still exciting that that piece of legislation was passed earlier this month. But like I said, some things are being introduced, but they're not necessarily being passed, and so that's also important to highlight. In Wisconsin, they had a bill that was going to create a new Office of Environmental Justice that was going to address climate justice, thing that I was talking about earlier, and unfortunately that was tabled earlier this month. And then Oregon, they had HB 12488, and that was going to be really impactful because it was going to require that the state change its land use planning goals to address environmental justice. So when they're approving permits or redistricting, things like that, they had to consider environmental justice, and that was tabled in this last session ending in June. And Illinois, it's been reported that they've introduced more than 40 bills at least referencing environmental justice in some capacity. And we haven't discussed it in full, but EJ can encompass a lot of things. So, but still 40 bills, that's a lot of legislation. Unfortunately, two of the major pieces that failed to pass, one of which was a clean energy bill that had some EJ provisions, and then another one kind of defining how environmental justice communities are determined, they failed to pass. So when we're talking about what's happening at the state level, it's important to highlight what's being passed, but also realize that there's a lot more work to do in terms of making sure that some of this legislation is getting bipartisan support so that it can actually be enacted and make the difference that we're hoping that it does. So switching gears now and kind of speaking more about what I tend to do on a day-to-day basis. It's really exciting. I'm so happy to be at Beveridge and Diamond, where I get to be in private practice and work on things like environmental justice, something that's like near and dear to my heart. And so I kind of tend to think of my work in two different categories. one of which is more prospective, helping companies think prospectively about environmental justice. And I put that in the compliance bucket. And then the other half is a little bit more reactive when we're in the litigation phase. So talking first about the compliance related work, a lot of it is just explaining to companies what is environmental justice. So defining that term because it is so broad, and also trying to make the argument about why it matters for their bottom line, why should they be caring about environmental justice. And even sometimes there might be someone more in the middle of the company that's really passionate about environmental justice, but they need to be able to make the business case to their superiors. So we help them to articulate the business case for environmental justice. Something else we do is a lot of benchmarking. So that's looking out at a company's competitors and seeing what they're doing in relation to environmental justice. A lot of companies, they don't want to be at the tip of the spear. They don't want to be the first person. But if you can say, hey, our biggest competitors, they have an environmental justice policy, and this is what they're doing in their community, and we have nothing, that can go over a little bit better, which is great. And then another thing that we help do is just looking at the existing policies that a company may have. Sometimes they might be doing a lot of things, but they might not be calling it environmental justice. So it's kind of linking together what they already have in place to create a cohesive environmental justice policy. And if they have nothing, which can happen, starting from scratch to help them craft these types of policies. And on the other side, in terms of the more reactive work, there's litigation. So it's really exciting. Can't speak in too much detail about ongoing litigation, but I've been involved with a case where we're assisting a government in bringing an environmental justice related lawsuit, which is really exciting work. And then although I haven't done any EJ related defense work, I anticipate that happening as there's a lot more enforcement action happening. So in my mind, I think it's really great to have people that care about the issue, believe in the issue on both sides of the V, so to speak. So we can actually make sure that these cases are being resolved quickly and effectively so that we can see the changes in the communities that so desperately need it. So just a quick couple of highlights for those of you in the audience who might be considering a career in environmental justice. Really get informed about it. Coming to seminars like this, really, really helpful. There's a lot of articles, books, and movies, so there's some resources on the screen, and feel free to reach out afterwards if you need some additional resources. Happy to share those with you. Another great thing to do is with these mapping tools that the states are coming out with, just take a peek around. Where do you live? Where do you work? Are you in an EJ community? Are you near one? It's really cool to get situated and to just know what environmental justice means where you live and work and how you can get involved. And then finally, there's a lot of really amazing NGOs that are doing great work. Donate and get involved in terms of political activism and shareholder activism. Maybe selfishly, because it'll make my job a lot easier if everyone who's a shareholder reaches out to their companies and says, I care about environmental justice. What's your policy? What are you doing? It makes a business case for attorneys who are trying to go in and create change regarding environmental justice. So yeah, with that, thank you, and I'll pass it off to our next panelist.
Thank you so much. And I think before we hear from Daria and Kiana, we are going to take a 5-minute break now. And so we will rejoin at 12:59 to hear from our last two speakers. So we will see you soon. All right, so I think that concludes the end of our 5-minute break. Hopefully everyone is back, and let's start back with Kiana. Kiana, the floor is yours.
Oh. Not letting me, there we go, okay. All right, well, thank you. Again, I am Kiana Courtney, and I am a staff attorney at the Environmental Law and Policy Center. Just a quick overview of the things I'm going to be talking about. I want to give some examples of what some of this work looks like from the NGO perspective, and talk about this work in Miami and Chicago and what coalition building with groups looks like, and then also cumulative impacts analyses. So hitting on some of the things that the other presenters have talked about. But first I want to take a step back and talk about the concept of community lawyering. So it's not actually something that my organization necessarily practices, but it's something that very much informs the work that I do. So community lawyering is a model that takes into account the long-standing systems of class and racial discrimination and oppression, which have resulted in the systemic powerlessness of whole communities. So that I got from the Community Justice Project, which I got to work with when I was in Miami. And essentially, as you are engaged in this practice, you are working with community groups in the struggle for change. You're not acting as a savior or a gatekeeper, and so you're really trying to pass off that knowledge so you're not relied upon, because that is how, or one of the ways that we can get to justice. So you're always self-reflecting on your impact. And so I also recognize that my presentation is going to be a lot of maps and red and green, so I apologize for the ableism there as well. So ideally what you're doing is transferring this knowledge. And so in Miami, oh, whole screen went away. Sorry about that. So I want to start off with the example in Miami. The picture on the right is what we call Old Smoky. It was a incinerator, a trash incinerator that was in the middle of a residential neighborhood, a Black Bahamian community. One of the first communities actually in the city of Miami, put there in 1925, was taken down after complaints from a more affluent neighborhood in the 70s, and was turned into a firefighting facility, a training facility. And what happened was that incinerator ash from that facility moved and was used as fill or soil in parks across the city of Miami. In 2013, it was discovered that this was a practice of the city, and parks were cleaned up, but only parks in the more affluent parts of Miami, and not so much even in the community where the incinerator was. So when I was at the University of Miami, we worked with community groups to file a complaint and for this practice to try to get these parks cleaned up. That case is actually still ongoing. And so that led us to, that work in that case led us to working with community members on a variety of other issues. So for example, there's this practice of upzoning or homes in Miami people can't afford to live there because of the taxes, or the larger, denser buildings are being condemned because the landlord isn't upkeeping it, and so people are essentially forced out. So your standard gentrification issues. But because of our work on the Old Smoky issue, it brought us into this work, and so trying to provide those services and that guidance to the community as a whole was important. So this is a picture of what Coconut Grove community looked like in 2005. And then this is a picture of what it looked like in 2016. So just to show you how over time the community has changed, is still continuing to change. because of these issues. And then just also want to flag, I don't know if you can see my mouse, but at the bottom, this is where the grove is, and you'll note that this is area in red. This is a redlining map. I wanted to flag this just to show that this is an issue that this community has been facing for quite some time, the issue of systemic oppression. And what I wanted to note that the notes for this area was that there are no disadvantages from the Negro perspective. However, this map is from 1940, and that incinerator went up in 1925. So the idea that there's nothing wrong with the neighborhood from the Negro perspective, even though there is an incinerator dumping ash every day on a community in their gardens, people still are facing issues with cancer and other health ailments to this day. Is just a classic example of the systemic issues that communities like this and several others across the country face. So I want to take us to Chicago, where I currently am. So I'm based in Chicago, which was once Kickapoo, Potawatomi, and Peoria lands. But on the left, you'll see kind of the demographic makeup of Chicago. So the orange is going to be your age, or your orange is your white population. The pink is more Asian, and then the darker purpley pink is Black, and then the yellow is more of your Latinx, Latina community. And if you look at the map on the right, this is a map of cumulative impacts that was created by NRDC. The red and orange areas have a worse cumulative impact score, and I'll talk about what that means in a minute. And then the yellow is a little bit better, and then blue and green, you're getting to the areas where there are fewer environmental burdens on the community. And you'll notice that there's some alignment in the color scheme here. And the Black areas are actually industrial corridors, so spaces where you're going to have scrap metal yards, warehouses, other industry. And you'll also notice that these are in these red and orange areas, which translate into the Blacker and browner communities in Chicago. So Chicago is a city that is economically and racially, ethnically still segregated. Oh, I don't know what happened. Okay. So cumulative impacts. When NRDC and what several other state agencies, don't know how it's glitching, but when several others, I'll keep going. Several other state agencies discuss cumulative impacts and environmental justice, and they're looking at the score or how to figure out what the impact is. They look at a variety of environmental characteristics and socio-demographic characteristics. And what California does is they take that environmental characteristic score and multiply it by the socio-demographic score, and then you get a number. And what California and other states do is they use that number to assign that, and what that NRDC map did was use that number to assign that score and show how incredible the burden is on certain communities. Other states also use other, as Rue talked about, other mapping tools, and they include other factors. So for example, Maryland looks at myocardial infarction and low birth rate infants. In Michigan, which is currently developing a mapping tool, looks at blood lead levels for reasons we all are probably aware of. So states kind of are also beginning to rely on communities to really develop what are some of those other factors that are important. It's something that they should be doing. So also wanted to flag Chicago, similar to Miami, the redlining map, also color gradation, also reflects this these systemic problems that are in environmental justice communities. For example, in McKinley Park, which is a neighborhood that's currently facing an asphalt or has an asphalt plant next to a school, the neighborhood once, the note stated that about the only way, or sorry, entire area surrounded by industry and odors are bad, especially when the wind is from the south. It is blighted and the future is hopeless. In another community in Inglewood, it stated, poor street with many colored, although 55th to 59th is fair, becoming better towards Halstead, where it was getting whiter. A Copernicus school recess looks like if 90% of the children are Negro. About the only way to stimulate white purchases is to rehabilitate homes and make them attractive. So in Chicago, we're still seeing the effects of this practice. So where does my organization come in? So knowing that there are neighborhoods that are just proportionately impacted by air quality in Chicago, and given how resources are distributed, for example, where the EPA FRMs are. So that map on the right is the little green dots are those monitors, and you don't really see them in the areas where you have environmental justice communities or communities that have high cumulative impact. And so we work with community groups around the city of Chicago, but also in other cities like Cleveland and Milwaukee to gather particulate matter data, because particulate matter comes from diesel, among other sources, but higher concentrations with diesel. And in that we are trying to, so we're working to gather particulate matter, PM 2.5, and PM10 data, and actually now PM1, because those are the particulates that really get in your lungs and exacerbate asthma and COPD and other ailment and heart disease and other ailments that you often find concentrated in environmental justice communities. So the city of Chicago also did a similar map recently in 2020. They also took into those factors I mentioned before, but also looked at health factors such as asthma and other social factors such as unemployment and housing. And lo and behold, map with a similar color scheme where you're seeing the west and south sides of the city most impacted. And then this brings me back to an earlier slide. So another example of a campaign really by community groups, and all of the environmental justice work in Chicago comes from the community. It comes from community members and the community-based organizations, and those community members are the real experts in this environmental justice battle for environmental justice. So the little black dot at the top is where a facility called General Iron was going to move to the black dot at the bottom on the southeast side or the east side neighborhood of Chicago. So to make room for a $6 million mixed-use river development. And the southeast side where it was moving to is moving across from a school and a park across the roadway. Most of the industry that was in that neighborhood is actually moving to other Black and brown communities as well. And so this is just a classic example of environmental, or what we see as environmental racism, because you've got a facility that also has a history of violations moving into an area that's already dense with industry and warehouses and higher rates of asthma and other ailments. So the community really worked together and really rallied the whole city and people across the nation to really fight this facility from moving from, oops, it went too far. Moving from the, can you go back? Maybe, okay. Oh, wait, back 2 slides now. Still the other way. Can you go back 4 slides? One more. Thank you. Okay, so this is in the background is the old facility, and on the right is the auto shredder fluff that the Northside community was constantly being exposed to. So it's actually a little small metal that they would find on the street in their backyards. And so that community didn't want, and we actually worked with that community to gather air quality monitoring data. But then we also, and the Northside community and several of the groups have all continually rallied for it to not move into another residential neighborhood. So what that fight led to was ultimately the several escalation tactics and the city and EPA deciding that a cumulative impacts analysis needed to happen. And that came from the push from the community. So I'm going to take a step back and talk a little bit about coalition building throughout each of these examples. So for example, with Old Smoky, we worked with churches and neighborhood groups to get to that class action lawsuit, but we also did a lot of organizing and documenting of what was happening in the community. But the biggest part was that we were showing up. We were working with community members to know that we were in this with them, and that that we were there to provide whatever services that they needed. In our air quality monitoring, we maybe it'll move forward. In our air quality monitoring work, we work with community groups to gather data and to comment on permits, to advocate against certain facilities, or to just build education. And then with that, we work with different classrooms, bike shops, ordinary citizens, community members that just want to know more. And we actually more recently started working with Microsoft to develop a stationary network of monitors across the city of Chicago. And with the Stop General Iron campaign, that was really led by organizers, community members, the community-based organizations who pulled together all of the larger NGO groups and other health groups, and just groups that had some tangential relationship to this issue, to put public pressure on the city, because this is something that this community didn't want. The community felt like they weren't being listened to by the city, and ultimately it got raised to a hunger strike where 3 to 4 community members were on strike for 30 days. And then we're slowly joined by other groups, and then there were solidarity days from other organizations as well. So a organization would go a day without eating. And then we also spoke at our national meetings, commented on the various permits that were needed, and then ultimately we built this strong coalition of groups across Chicago that when we are faced with other facilities or other industry that the community doesn't want, not only in this neighborhood but in other neighborhoods, we have the tools and we have the partnership to engage in that work, because all of this really takes trust. You don't just hop into it, right? You have to build those relationships. Even though if you're all on the same team, everyone has a different value system and a different set of goals, and oftentimes the larger environmental organizations are known to use the community-based organizations for their agenda, because everyone has an agenda. But that's why it's important to really build trust among the different groups to be able to get to the change that you want to see. And so ultimately, with the General Iron campaign, we got the EPA to step in and say that the city of Chicago needs to hold off on this permit, that it's going to allow General Iron to operate, and needs to do a cumulative impacts analysis, so a holistic look of how this community is being impacted, but not just this community. We want it to happen throughout the whole city of Chicago. And we're using and relying upon some of the work that's already happened in Illinois with community solar, with California, the legislation that happened in New Jersey, and really leaning on that blueprint and that legislation. Chicago had already promised that it was going to do a cumulative impacts ordinance. So we're in a working group where we are working to develop that along with other environmental justice policies in the city. And then there are other states also to look and rely upon that are doing this mapping and this analysis that Rue had mentioned earlier. And so ultimately, the goal is to achieve justice in a way that Professor Torres talked about earlier, where it's not just about getting certain facilities out of the neighborhood, but that people just have clean air to breathe in every neighborhood in Chicago and free LPC across the Midwest. And that's it for me. Thank you.
Okay. Let's see here. All right. Well, thank you, everyone. And it's just really great to be here today with these amazing attorneys. I'm really excited to be here to speak to you. So again, I'm Daria Neal, and I've been asked to speak about the impact an attorney can have on environmental justice issues while working in the federal government. So there are numerous ways a federal government attorney can address environmental justice issues. Depending on your position, you may be enforcing certain statutes, you may be defending federal actions, and you may also be shaping policy decisions. I've been at the Civil Rights Division for over 10 years in the Federal Coordination and Compliance section at DOJ. Prior to joining DOJ, I worked for the Lawyers Committee for Civil Rights as the Senior Counsel for the Environmental Justice Project. So today I'm speaking in my personal capacity. I am not speaking on behalf of the federal government or any other entity. So there are numerous laws that can advance environmental justice, and they are not limited to environmental laws. I'm going to focus my remarks today on where most of my experience has lied. That's been with the enforcement of Title VI of the Civil Rights Act, which Professor Torres spoke about earlier. And I do want to note that also the Fair Housing Act can also be a tool for addressing environmental justice. So I thought it would be beneficial to start off with some background on Title VI and then how it's used in the EJ context. So for those of you who may not be familiar, Title VI prohibits discrimination on the basis of race, color, and national origin in programs and activities that receive federal financial assistance. So that would include state and local governmental agencies like Texas Department of Transportation or Illinois Environmental Protection Agency. Federal agencies such as EPA, Department of Transportation, Health and Human Services, all provide funding to a range of state agencies that operate programs that affect the environment and human health. So when it comes to Title VI enforcement, the federal government is really in a unique position compared to the private bar. Federal agencies have the authority to enforce Title VI and do not need to do so by filing a lawsuit. Agencies' enforcement authority also includes ensuring compliance with their own Title VI regulations. The statute itself provides for federal agencies to publish regulations to implement Title VI. All agencies that provide assistance, and there are about 26, 27 federal agencies that do so, they have their own regulations. And they are fairly consistent across federal agencies. And they state that recipients of federal financial assistance may not directly or through contractual or other arrangements utilize criteria or methods of administration which have the effect of subjecting individuals to discrimination because of their race, color, or national origin. For decades, it was understood that Title VI prohibited intentional discrimination and activities that have racially discriminatory effects, and that individuals could sue in federal court to address both forms of discrimination. But in 2001, as Professor Torres noted earlier, the Supreme Court interpreted Title VI to only provide individuals with a cause of action to address intentional discrimination. It did not, however, void federal agencies' regulations that address discriminatory effects or the ability of agencies to ensure compliance with their regulations. So the result has been that only federal agencies can address discriminatory effects in programs that receive federal financial assistance. So I provide this background because efforts to address environmental racism and discrimination are not just limited to enforcement of environmental laws. Many communities and legal aid organizations seek to address these issues by filing Title VI complaints. And they do so by filing them with federal agency civil rights offices. So when a state agency, like in the example that Kiana provided in Illinois, may engage in a permitting program that results in polluting activities being concentrated in African American communities or in a Latino community, one way to potentially address the matter is by filing a Title VI claim with the federal agency. And as a federal government attorney, you would be responsible for analyzing these claims, assuming you're in the civil rights office. And frankly, it's a really important responsibility because whatever outcome your investigation results in is one that only the federal agency can do and negotiate. Attorneys are often housed in agencies' offices of general counsel, but most agencies have a civil rights office that hires attorneys. Usually they have an analyst title and not an attorney title, but they essentially do the functions of an attorney, which is conducting investigations, doing witness interviews, and making findings. EPA's External Civil Rights and Compliance Office investigates most Title VI complaints that raise environmental justice issues, but the Department of Transportation, Health and Human Services, Housing and Urban Development, and even the Department of Agriculture frequently handle environmental justice Title VI complaints. So federal attorneys also can have a role in implementing an administration's policy priorities. Frequently, this is done by issuing regulations or policy guidance. I know that there are many folks who are participating in this seminar today that are from state agencies, state environmental agencies, or transportation agencies. As recipients of federal funding, you know that the federal government will often publish regulations to implement statutes and issue guidance to assist recipients in complying with various laws, including civil rights laws. Often lawyers are drafting these regulations and policy guidance. And so when it comes to Title VI, the ultimate goal of the statute is to ensure non-discrimination in programs that get federal dollars. There's this clear recognition that states and local agencies need federal dollars to carry out certain critical activities benefiting the public. So taking away federal money really is the last thing that the federal government will do. And in fact, it has rarely happened. The statute and regulations require the federal government to make sure that every effort is taken to ensure voluntary compliance. So this is where guidance documents come in. Those are often intended to assist regulated agencies in their efforts to comply with the law. So what impacts can you as an attorney in the federal government have in the context of environmental justice? Well, whether you're enforcing an environmental statute or civil rights law or defending federal actions or shaping federal policy, it is important to understand the impact of your work on communities that are burdened by pollution from varying sources, whether it be highways or industry. You often have discretion to negotiate resolutions that do not further exacerbate disparate burdens. And I would encourage all attorneys, federal and otherwise, to consider the concerns of communities impacted by the litigation or investigation that you're handling, and to consider their concerns when developing the terms of any settlement agreement. So several years ago, the Department of Transportation negotiated a resolution of a Title VI complaint that involved a bridge construction project. The site that was selected for this new bridge would have dissected two predominantly African American communities, isolating residents from businesses and churches, and leaving them surrounded by polluting sources. So there would be a bridge on one side, the highway on another, and a shipping port on a third side, effectively isolating this community. So the Department of Transportation determined that there were other sites for the bridge that would have had less discriminatory impacts. And they actually issued a finding of a violation of Title VI. One of the terms of the resolution agreement that they reached was the establishment of a community advisory committee to work with the state agency as it proceeded with the project. So although the bridge project proceeded at the same location, the community was able to be involved and frankly, the state recipient was required to include the community through this advisory committee to try to mitigate the impacts and to address community concerns as the project proceeded. And DOT was also able to have the state recipient agree to provide compensation to residents to relocate if they so chose to, and to make improvements to community spaces for residents remaining in the area. And frankly, I don't think any of this would have been accomplished if the community and their council had not filed a Title VI complaint with the federal government. So often we see huge infrastructure projects proceed and really not take community voices into account. And before you know it, they're constructed and our communities are often become isolated or frankly destroyed. And I think it's really important that whatever role you're playing, that you engage with communities that are impacted, that you talk to people. I am amazed how often attorneys are tentative to engage with residents who are impacted by a significant an industrial project or landfill project. But those are the people who know exactly what is happening on the ground and can give you historical context for what has happened in their communities and how they've engaged with their local government. And if your resolution includes any type of mitigation, the mitigation should benefit those who are impacted. And you can't know that unless you're talking to people. And so it's so often you as the attorney will not be able to give the community everything that it wants, but oftentimes there is a lot that can be done to address the community's needs. I'm also a huge proponent of federal agencies collaborating with each other to reach resolutions that achieve a holistic benefit for communities. And I think that bridge project that I described earlier is an example of that. Department of Transportation worked not alone, but engaged with agencies like HUD and EPA as they work to negotiate a resolution agreement. And oftentimes there'll be a complaint, a Title VI complaint may come in or may be filed that raises a discrete matter that involves, let's say, one industrial plant or a highway expansion, but there may be related issues impacting health services or housing. And so communication and collaboration among federal agencies can really lead to more effective solutions. And I think it's imperative that attorneys in the federal government actively engage in that type of collaboration and coordination. Many of you may be aware of, and I believe Professor Torres had also mentioned the Federal Environmental Justice Interagency Working Group, which is now called the White House Environmental Justice Interagency Council. The goal of that council is to develop a strategy to address current and historic environmental injustice by consulting with the White House Environmental Justice Advisory Council and with local environmental justice leaders. So there's already a recognition that there's a need to engage with EJ leaders across the board in trying to address past and current environmental injustices. The Interagency Council is an opportunity, I think, for agencies to work together to address environmental racism, past and present, and discrimination. And to frankly think about strategies going forward as we look to rebuild the infrastructure of this country. There's going to be a huge amount of money being flowing into states and local government to rebuild infrastructure. And that needs to be done with an environmental justice lens. We can't continue to build upon the past decisions that may have been rooted in racism and discrimination simply because it's easy. And many recipients of federal funding get funding from multiple agencies, which is why collaboration among agencies is really important. And I think that collaboration also occurs not just when it comes to investigating complaints, but also when it comes to providing guidance. Often, I think state and local agencies get a lot of messages from different federal agencies about what they should be doing. And I think to the extent agencies can come together and jointly issue guidance that can help state and local governments determine the best way to be in compliance, will ensure consistency and effective compliance with civil rights statutes. And so really, I think that federal attorneys are uniquely positioned to address environmental injustices, whether it's through our litigation or our policy work, can have a real meaningful access on communities, real meaningful and positive impact on communities. And so I'm happy to answer any questions during the Q&A period. Thank you.
Thank you so much, and thank you to all of our panelists. I'd like to give them a virtual round of applause. That I know that I found that very informative. And so now we have quite a few questions from our audience, which is great. So we're going to try to get through as many of them as possible. So to our panelists, if I ask a question and you want to jump in, please feel free. So the first question I'm going to ask deals with the importance of terminology in this movement. Is environmental justice the overall umbrella term, housing environmental racism and Indigenous environmental justice within it? Are some terms better than others for this movement?
I don't know. I guess I can take first. Am I muted or can you hear me? Okay, good. I'll take a first cut at this, but obviously everyone else should correct me when I get it wrong. Environmental justice, I would take to be in many ways the umbrella term. You know, at the beginning of the movement, environmental racism was the predominant way in which the issues that are raised by environmental justice were characterized. But in some ways, that created a focus that permitted critics of environmental justice to deflect the critique that the environmental racism movement, environmental justice movement was making. So the umbrella term, I think, is environmental justice. They're going to be, and this is one of the things the activists, but also the academic critics have noted, right? They're going to be specific expressions of environmental justice that will have different emphases, but within the claim that justice has to be at the core of these policies. So maybe I'll leave it there.
Would anybody like to add a comment? All right. I will move on to our next question. And again, feel free to have this as a free-flowing dialogue. But I know everyone on the panel has entered this area of work at different points. But what would you say, as the movement evolves, have the goals changed since you entered? And how have the challenges changed or stayed the same since you entered this area of work?
I'd urge someone else to speak. Otherwise, I will talk, and I'm not shy, so I apologize for it. I think it's become more refined. The number of people who are actively involved in both framing the idea at the level of the movement and then translating it across the various institutions has actually refined the idea in important ways and given it different kind of a different institutional focus. And people need to recognize that when you're engaged in a legal institution, where you're engaged in a political institution, where you're engaging communications generally, right? The way in which things get phrased, or to take Dr. Middleton Manning's, right? If you're going to involve Indigenous questions, the set of legal questions are going to be different, right? And it then raises things like decolonization, which complicates the issue. But as Daria Neal said, the government has got to figure out where it can get a handle on this. And some of this is we're dealing with imperfect tools, and I hope that the use of those tools can help us design new tools to do it. I think some of those different approaches have already been discussed.
And to add, I think one of those tools has been the use of social media, especially with the organizers that we work with and that work across the space. The ability to rally so many people so quickly and do different actions, multiple actions in a day, has been effective, I think.
Yeah, I would absolutely agree with the increase in social media and the attention that is brought to the high levels of the federal government. I mean, Kiana, your slide with the administrator and the mayor of Chicago, I think really points to that. And I don't think that would have been possible without the intense pressure that advocates put on the city and the national attention that that matter got. And I think within the federal government, one thing that's quite amazing, frankly, is that environmental justice has survived. There have been periods where it's been dormant, but Executive Order 12898 was signed in 1994, and it has never been rescinded. And we are here today with White House office agencies looking at or councils looking at ways to build upon that executive order, because there's a recognition that times have changed. What is it, like 30 years maybe that it's been, and that there are unique issues that communities are facing, that we're facing as a nation, that we're facing across the globe. And to Professor Torres's point, that our tools are imperfect, and I think that as agencies try to dig in and to use what we do have, we can recognize where there are limitations. And I think the increased pressure from the public on the federal government and even state governments can identify where there are gaps and hopefully work aggressively to address those gaps, whether it is through, new legislation or specific policy changes at state level, local level, and even the federal level.
Thank you for that. I think I might add something about research because on the one hand, there's a lot of an increase, I would say, in grassroots, community-based research happening, people doing air monitoring, water monitoring, et cetera. And there's also expansive tribally led environmental departments also monitoring and doing research. And so that is exciting. I think, speaking as an academic from an institution, that there's still a gap between some of the intensive environmental science research, toxicology, water monitoring, et cetera, and on the ground issues, that we do generate some powerful research in academic institutions about toxics and remediation, but it doesn't necessarily make it to the community issue. So I would like to see more work to bridge that gap. I think more often than not, tools are developed that maybe go into the private sector, but they don't necessarily get into the hands of community members. So I would like to see more work there. Another exciting element in terms of what I think has grown and changed in EJ, and maybe this is something that's been moving across time, but the connections between diverse groups of people facing impacts from the same institutions that are crossing both, regional boundaries as well as state and national boundaries. So the same pipeline companies, for example, that are causing illnesses way up north in Alberta, communities up there, there are coalitions of people that are very diverse from each other fighting against those same companies in the plains and out in the Gulf. So I think, and that social media that was mentioned earlier facilitates that connection and that building bridges across difference to address both problematic public policy and renegade private companies.
Thank you. Those were all really engaging answers. So for our next question, how can state environmental rights constitutional amendments help promote the pursuit and achievement of environmental justice?
I'm happy to take the first crack at that. Yeah, these so-called green amendments, which essentially provide citizens with a constitutionally enshrined right to clean air and the environment, they actually have potential to really bolster the environmental justice movement. And essentially it's just another tool in the court's tool belt when they're trying to decide these issues. And so if a citizen has a constitutionally enshrined right to clean and healthy environment, that allows the court to rule in their favor. So it's similar to the creative case law we saw with Juliana, with like the young people bringing lawsuits using creative legal theories. If these amendments were to pass, it's just another tool in the tool belt. And so I believe New York is considering one currently. Hawaii has something that's already been passed that kind of encompasses this, but and internationally, other countries have in their constitutions individual rights to clean air and the environment. So I think it's a very exciting area. Excited to see how that's going to kind of fold out at the state level.
Yeah, I think it would really be a useful tool. Because right now, as Rue mentioned in her presentation, there's a large fight for legislation. But what's stronger than legislation is having a constitutional right to some extent, at least to courts, and being able to rely upon that tool. I think as it was in Pennsylvania, it would make this fight a bit easier, especially given, as Professor Torres mentioned, that environmental laws really weren't made to incorporate environmental justice and a lot of the concepts that we've been talking about.
All right, so I'm going to keep going through the questions because we have quite a few. So the next question is, there's ample helpful material on understanding greenwashing, but has anyone done work on creating similar resources for corporate EJ washing?
I personally haven't seen anything regarding EJ washing, and I like that term. I mean, as soon as corporations are getting involved in matters like this, it makes sense that some of them are not going to be authentic or making good on those promises. But like that said, I do believe that having policies in place, EJ policy in place, it really does help internally those who are passionate about the issue to have something to refer to when they're just trying to make decisions based on EJ principles. And then externally too, having that legislation. So in New Jersey, if you have to do an environmental justice impact statement, it's hard to greenwash that. So it's also good to have that external check as well on these companies. But yeah, I think the same tools that we look to assess whether a company is engaging in greenwashing, we should be doing the same thing in relation to EJ washing. And I'll be excited to read any literature that comes out on that.
So I just want to add, and maybe this might be an ask of Rue. I mean, to the extent that we can engage with corporations on the front end, and I think you might have mentioned that during your remarks, and educate them on how they can ensure that their practices don't continue to overburden communities, or in fact, help to alleviate burdens on overburdened communities, I think is really important. And some frankly, I'll just speak because I had personal conversation with some friends recently, and to the extent that an organization may be engaged in clean energy practices and developing new clean energy, I think often that can happen in a silo, right? Like you have a really great goal of trying to reduce carbon emissions or to mitigate the impacts of climate change. But at the same time, there's the need to think about your approach and whether your approach to achieve this broader goal is in fact going to burden some communities over another. And that needs to be another layer that's taken into account as we start to see all of these advances to develop clean energy, green energy, and address climate change. And so to the extent that that education happens, whether through counseling your clients or encouraging them to have some type of internal program that helps them to think about environmental justice in every aspect of their work, might be another way to prevent EJ washing, corporate EJ washing.
I would just add, I think that state policy can be very important there as well. Carbon offsets are controversial in many ways. I know with California, we have that decreasing cap in the policy from the Air Resources Board. So corporations can offset up to 8%, but the overall cap is decreasing. I think that you need that kind of policy even going further, because I think in other places offsets can be purchased without an overall requirement to decrease emissions. So it's that type of policy is very important.
Thank you. So our next question says, is it useful to argue, since cumulative impacts are considered in water quality permits, that similar methods should be used for air? Or is there any reason not to draw parallels among other environmental regulations in the pursuit of environmental justice?
If you go back to the original executive order, you'll see that the original executive order called for the agencies to initiate cumulative impact reviews, so that even where it's not directly articulated in a particular statute, the agencies do have it within their power to begin those reviews, if for no other reason than to inform how they can best do what they are required to do under the statutes. So the tool, the instruction is there. Whether it gets done is a separate question, but absolutely should be considered.
And I don't think you would use necessarily the same metrics for each one, or you could. I think it would be very dependent upon where you are, and also it's important to rely upon what community members see as important factors to consider. And so I think it's a larger formula, but it is still important to draw those parallels as well.
Thank you. And this next question puts Dr. Middleton Manning in the hot seat. Has there been any research efforts with a focus on designing some type of channel for the salmon to migrate upstream to try to mitigate the impact of such dams you mentioned?
Yes, there's a lot of work on that, developing fish ladders and other types of fish passage. I don't study that specifically. I know that for some of the older dams that were built without that type of mitigation in mind, I think it's very hard to retrofit them to provide fish passage. And in the particular river I was looking at, there are, I think they call it a 10 dam stairway of power. So there are multiple dams. The image I was showing you was just from the largest one, which is also one of the largest dams, if not the largest dam in the State Water Project, Oroville Dam, the fish hatchery there at the base. So yes, there's a lot of work on fish passage. I'm not sure how well it can be implemented with older infrastructure.
Thank you. And our next question goes to volunteer engagement. So with voluntary organizations, how can you sustain volunteers with a knowledge of how long environmental justice campaigns can take and how long they might take to make a real impact? And how do you make sure that these volunteers and these campaigns don't get discouraged?
I think that's a question that we're always asking ourselves. I'm thinking in particular with some of the Enbridge pipeline fights. So for example, one of my cases is about Line 5, and one of the things that we often talk about is just how to keep the drumbeat going, knowing that it's going, this case is going to take quite some time, and there are a lot of different permits and agencies and different venues. Some of it's federal, state involved, and part of it is when you get into this work, you kind of know that going into it. And then it's also okay, knowing that it's okay to engage in it in a way that works for you as a volunteer, because you also don't want your volunteers to burn out as well. So constantly keeping people abreast of what's happening, but also knowing that people are going to be in it for the long haul, but some people are going to bow out and come back. So it's just figuring out a way to kind of balance all of that.
And I think the last question I'm going to ask, so we can end on time, really connects with that. Since you can't pour from an empty cup, how can those working on environmental justice issues, so lawyers or others, how can they take care of their mental health and make sure that they're taking care of themselves to sustain these efforts?
I was just about to say that the mental health question was deeply related to that previous question, because one of the biggest challenges is when you see ongoing health issues. So from smoke, from pollution, from, for example, in Owens Valley, the dust from the dry lake bed from the water that was taken to Los Angeles. I mean, when your people in your family are facing the asthma and the other conditions, I think that is the hardest part about how long the fight takes. All I can say is pointing to the successes, maybe even the small wins, and also empowerment in the community. I really do love these community-based monitoring projects where people are amassing the data themselves and bringing forth that information constantly at all different forums. So that's all I can say in terms of hope and empowerment and mutual support.
Yeah. Oh, go ahead.
No, Kiara, go ahead.
I really agree with the mutual support point. In a lot of the different cases, you really rely upon others in your team and in the coalition of all the different organizations. For example, in some of my coal ash work, knowing that there are going to be some losses along the way, but ultimately getting to the goal of getting that pollution cleaned up and supporting each other is really key. And having those check-ins and the virtual platform, being able to use that even before the pandemic was helpful, because we could see each other and discuss tactics and how we wanted or certain things that we wanted to ask for in rulemakings, or having that collaborative space where you can really rely upon others, I think is an important tool in being able to kind of maintain that level of sanity, because knowing that ultimately you're going to get to the goal you want to, it's just a matter of how long is it going to take. Optimist hat on today.
Well, I would like, oh, sorry, go ahead, Rue.
Sorry, I was just going to say I agree with all those points, and I think it's also important to remember the history of the movement and how long it's been going on for, and to also realize that even if you're taking an action today, so you propose a piece of legislation that's gotten tabled, you have no idea, whether it's going to come back later or what's going to be built off of the foundation that we're laying today. So even if you can't see immediate results, just remember the long game and remember how long the people have been doing this for.
I really support that view. I mean, it's having a longitudinal perspective is critically important. Really, really important.
Thank you. And thank you to all of our panelists today. That it's been such a pleasure talking with you and learning from all of you. Nina?
Perfect, thank you. And I would just like to say a final thank you to all of our participants for joining us today for our final summer school session and for all of your incredible questions. I know that we had far more than we were able to answer, but I strongly encourage you to continue asking these very important and critical questions and to keep exploring the important topics that we've covered today. Finally, an incredible thank you to our outstanding group of panelists. We appreciate your contributions to today's webinar and our final summer school session of the year. And thank you again for lending your insights and experiences from your leadership in the field to make this such a fascinating and informative program. Thank you all, and stay well.